All persons having business before the Honorable Associate Judges now presiding over the District of Columbia Court of Appeals, draw near and give your attention. God save this United States and this honorable court. This honorable court is now in session. Please come to order.
Good afternoon, everyone. Welcome to this remote session of the District of Columbia Court of Appeals. The matter we are hearing this afternoon is number 19 CF 0814 CAMILLE Covington versus United States. And if you are ready, Ms. Allen, we may proceed.
Thank you. Nancy Allen on behalf of CAMILLE Covington. Ms. Covington, in this case, Your Honor, contends that the complainant's injuries were not exceptionally severe, if not unbearable, and the government failed to prove that beyond a reasonable doubt. The Dominic White case recently stated that pain that allows victims to pursue their normal lives does not rise to the standard of extreme. And in this case, Your Honors, the government contended at court that the basis for their serious bodily injury proof was four things. Ms. Sanchez, the complainant's testimony regarding her extreme physical pain. Number two, the immense loss of blood. Three, that she was on yellow alert at the hospital. And four, that she had to have surgery for a severed vein. And we'd like to address those initially. First of all, there was no testimony regarding extreme pain from the complainant. The complaining witness.
Can I just interject as some plate setting here? At the MJOA stage, where there is no motion for judgment of acquittal on this charge, I believe, defense counsel is asked, do you agree that there was testimony from her about the extreme pain that she suffered? The answer is yes. I mean, I don't see how, if the court made a mistake and letting that go to the jury and entering a judgment of a verdict, I don't see how you didn't invite that error.
Well, Your Honor, I think that was a lapse of judgment on defense counsel's part to agree with that. They were having a discussion at the bench regarding the malicious disfigurement charge. And it appears that defense counsel was focused more on that, more on the misidentification testimony. The key point we want to make about that, Your Honor, is the cases the government cited regarding appellant taking a position contrary to what he or she took at trial, all talk about situations where defense counsel actually argued to the jury, or for example, in Brown specifically asked the court not to give an instruction on a point he later contested on appeal, arguing to the jury something that later was contested on appeal. So our contention is that, yes, defense counsel misspoke. It was a lapse of judgment, but it was not an argument made to the jury. It did not affect the jury's consideration of the case. Does that answer the court's question?
I mean, so far as it goes, yes.
Okay, so continuing with the government's proof, first of all, there was zero testimony from the complainant regarding extreme pain. What she said is she did not feel like she was being cut. She felt blows, and then she saw blood, and she knew she was being cut because she was bleeding. She was scared and nervous at the blood. The only time she talked about pain was when she said her head was really hurting. She was hospitalized probably from a little after 8 that morning until the afternoon. She wasn't admitted. There was no testimony regarding pain from the doctor.
Ms. Allen, to what extent are we allowed to kind of look at the photograph of the complainant and think that looks like that must have been really painful. Is that allowed?
Well, Your Honor, I think the photographs are a factor, of course, but the government also has to, a photograph is worth 1,000 words. The government still needs the 1,000 words. They still need to prove beyond a reasonable doubt extreme pain, and the inability, or what this court said in White, is the inability of the victim to pursue their normal life afterwards. So,
and does that mean, you mean like a week later, or how long does the pain have to be occurring at the time of the offense, or, during treatment? It doesn't seem like, if they can't, I can imagine a situation where someone would have extreme pain during the offense or even in the immediate treatment, but pursue their normal life the next day.
Which is what happened in the Dominic White case, where the complainant said, my pain level is 10. And yet the court pointed out he was able to go back to work. He had migraines. He said he vomited sometimes. He couldn't drive a tow truck immediately. He had to work in the office, but eventually he was able to pursue his normal life. In this case, we have zero testimony regarding whether or not Ms. Sanchez was able to pursue her normal life. There's just nothing about, other than the fact that she saw a therapist and was prescribed a medication for nightmares. There's nothing in the case about medication that she was given for pain either.
Do we know that she was not given medication for pain, or there's just the government put on no evidence of that?
There's zero testimony regarding medication for pain. No medication for pain at the hospital. No medication for pain that she was given upon release that afternoon from the hospital. There's nothing about medication for pain. There are no medical records entered into evidence, and the doctor didn't testify to medication or to pain. The one point the government brings up in its brief says the doctor testified that the complainant had to get medical treatment to, quote, prevent further physical pain. That was, we contend that was actually an answer to an improper question by the prosecutor at trial that assumed facts not in evidence. The government had not, the doctor had not testified to anything regarding pain when the prosecutor asked, did she need medical treatment to prevent further physical pain? And he simply answered.
What was the answer to that question?
He said yes.
Yes.
However, he hadn't testified to pain, period, at all until that point. So
how should we think about the fact that there was an interpreter involved in this case, or should we think about it at all? I mean, the reason for my question is this. I mean, you could imagine an interpreter hearing something that was more detailed than "my head was really hurting," but translating it as "my head was really hurting." Is that a factor we should consider?
I don't think so in this case, Your Honor, because as is clear from the transcript, the prosecutor was well-versed in Spanish. One of the prosecutors, I can't remember which one it was, brought up a couple of times to the court when the interpreter misinterpreted. One time specifically when the complainant said stranger and the interpreter called it light, or there was some sort of confusion with language. So I think in this case, had that been the situation where there was a vast misinterpretation and she didn't say I was really hurting, but I was in agonizing pain, I think the government would certainly have approached the bench, because they approached the bench for lesser misinterpretation.
Possibly, but I mean, I could see the witness saying something like, "I had terrible pain." Translated, "my head was really hurting," and I'm not sure that would have caused anybody to intervene, but it might have been an answer closer to extreme pain. I'm just curious as to your thought about that.
I think we have to rely on the ability of the interpreter to interpret precisely what the witness said. Otherwise, we can just conjecture all day long, I think, about whether or not what was interpreted was really what was said. So I think in this case, particularly where you have a prosecutor who does speak Spanish, certainly that the prosecutor wouldn't have let that go by in this particular case.
Would you mind pivoting, unless my colleagues want to stay on this topic? Can we talk about protracted disfigurement?
That was an interesting point. The trial court, sua sponte, dismissed the malicious disfigurement count, noting that the government had made no record of a connection between the assault and any scarring at trial. And specifically on page 42 of the government brief, the government contends, well, the jury was able to compare the complainant's face with the photographs and cites June 4th, the trial transcript for June 4th, pages 63 to 65. There's in fact no comparison in the transcript for those dates. What we're seeing, what we're hearing, what we're seeing on the—
I just want to put comparison with her presentation at trial aside for a moment.
Okay.
Because one of the government's principal cases is a case called Gaffey, which, you didn't file a reply brief, or at least none that I've seen, that has responded to it. And in Gaffey, there is no mention of comparison between photos and the presentation of the victim at trial. Instead, what there is there are photos of the victim at the time of the attack and 1 week later. And we said, based on their location and severity, I'm not even sure if we had the photos in that case, other than maybe it was just a description. I couldn't tell if we had seen them. But here we have them. And basically, I think everything we said in Gaffey would apply here. Based on their location and severity, there's no question that this was going to be protracted scarring. There are deep cuts that require, as the medical testimony testified to, required multiple layers of sutures and required follow-up treatment to prevent further scarring, or I think it said more severe scarring, suggesting that some was still going to be around. Strikes me as a stronger record than Gaffey, although there were, I think, a few more stitches involved in Gaffey. Here, I think the total comes up to something like 40 stitches in her face, but it's a lot, and the photos are dramatic.
I think the largest number of stitches for a particular wound in this case was 14.
I was adding them up.
Yeah. Well, I think our contention is that the photos alone, certainly, for example, Your Honor, if I were to see a photograph of a severely injured ankle, I would say to myself, that seems like exceptionally severe, if not unbearable pain. However, without more information, I just couldn't make that. I
guess I need you to distinguish Gaffey for me, though, because Gaffey is this case. It is pictures of serious scarring in the middle of the face from similar type wounds, and the court said good enough.
Well, Your Honor, I think that there is an issue here with the fact that the jury was not invited to look closely at the complainant's face here 3 years after trial to determine whether there was any scarring. And that's exactly the point.
That didn't happen in Gaffey, though, either, did it?
I think, Your Honor, court's brief indulgence.
Sure.
I'm just going through my people.
And I think the court's just talking about the photographs.
Well, Your Honor, in Gaffey, where there were a number, 48 stitches, Gaffey also did note that other factors would be relevant, and the length of the hospital stay, the number of stitches, the victim's behavior immediately after the assault, whether the victim received prescription medication for pain. So our contention is this case is far more like the Dominic White case and Jackson, where
in Jackson, what we said was there's no question that this was protracted. It's just that the location of the scarring was not so obvious as to be considered serious, because I think it was on his ear.
And the court held in Jackson that the pain there did not rise to the level of exceptionally severe, if not unbearable, despite the fact that the complainant was beaten with a hammer, had lacerations between 2 and 4 inches long, substantial bruising.
Yeah, sure. I'm just curious on the protracted disfigurement part, though.
Well, I think the trial court was correct in dismissing sua sponte, that malicious disfigurement charge, because there's
That's not the question for us. I mean, that involves permanent disfigurement, and whether the trial court was right or wrong about that is really neither here nor there, so far as I'm concerned. You know,
I think the problem for the government in this case, Your Honor, is there's no proof of any kind of protracted disfigurement. We see.
So Gaffey says the photos are enough.
Well, Gaffey says the photos are compelling evidence in addition to other factors.
Those other factors didn't speak to protracted disfigurement, though.
Well, Your Honor, I think the government in this case specifically relied upon certain points that they made clear: extreme pain, immense loss of blood, the yellow alert, this severed vein. And our contention is that, at least as to some of those points, the government engaged in a little bit of hyperbole.
One more point on Gaffey is, I just went back to look because we had this conversation earlier, and the answer is not only was there no comparison at trial, the trial indicated there were no permanent scars. It says, though the court remarked that at the time of trial there were no permanent scars, common experience teaches that wounds requiring multiple stitches are likely to leave some scarring, however faint, and that scars in the center of one's face are more visible and prominent and thus more disfiguring than they might be elsewhere. Here, I grant you that the jury is never invited to make a comparison. However, if we are to glean anything from this record, there are a repeated number of references, both not to the jury, so that's query whether or not we can take them into account. There are repeated references to her scarring still being present. It comes up quite a bit at the sentencing hearing in ways that are, make it quite clear those scars are still there. So unlike Gaffey, where it actually was gone and we still said the photos a week after were enough to find it protracted disfigurement, here, all indications are she still had them 3 years later, which is when this trial occurred.
However, Your Honor, at trial, the government did not invite the jury to take that into account in their decision, in their verdict.
Because you didn't dispute it. The defense never said there was no protracted disfigurement. This wasn't a serious bodily injury. So that kind of circles back to the invited error point on extreme pain, but I won't rehash that. But I mean, the things that you would want them to do, I suppose I'm still just waiting for a distinction of Gaffey that's meaningful and protracted disfigurement, and I don't think I've heard it yet.
Well, Your Honor, I would like to point out that the defense was misidentification. And so that was the full thrust of their defense. The government in closing focused also on misidentification. There's only maybe 3 sentences where the government in closing talks about the aggravated assault count, and in their closing argument talks about the pain and the amount of blood, but doesn't reference, actually doesn't even reference the court's brief indulgence, making sure. Doesn't even reference the photographs. So
does it refer to disfigurement?
No, Your Honor. No, in the government's closing, the government talks about she doesn't realize that she's been cut until she sees blood. Her face was sliced up. She lost a tremendous amount of blood, and she felt weak.
So is your point there, if the jury was going to find Ms. Covington guilty on the ground, of ag assault on the grounds of protracted disfigurement, they were going to do so by looking at the complainant themselves without invitation and trying to figure out what they were seeing.
Exactly, Your Honor. And during the time that the complainant is pointing to the injuries on the photographs, presumably the courtroom lighting is low, the photographs are on a screen, the complainant is in the dark and pointing to these injuries. There's just no testimony at all that the complainant was shown to the jury. The jury was not invited to look closely at her. And there's a number of factors that play into the jury.
I will just, as I looked at the closing arguments, the first thing the government says on serious bodily injury is, we know there was serious bodily injury caused Ms. Sanchez. Her face was sliced up. I mean, they don't utter the phrase disfigurement. Sure sounds like it though. I mean, it seems like they are appealing to the disfigurement prong of serious bodily injury there.
They are talking about the wounds, and they're talking about the immense loss of blood, which I do want to address, because I think some of this is a little bit hyperbolic. The doctor testified that the amount of blood lost at the hospital was 4 times what one might give in a regular physical. And for a regular physical, I don't know about Your Honors, but it's generally 2 tubes of blood about the size of an adult pinky. So, 8 tubes of blood. There's nothing really to compare it to, but it seems like immense is a little bit of hyperbole in that situation.
I took him to mean 4 pints. That's not how you read it, as in what one might donate when they sit down to donate blood.
No, it was what one might give at a regular physical. It wasn't a blood donation. It wasn't like a Red Cross blood drive. The doctor specifically said what one might give at a regular physical, 4 times that amount.
And Ms. Allen,
Your
can I?
time is- Oh, sorry.
Oh, I'm sorry, Judge Thompson. One quick
quite all
question.
right.
Can you clarify what the judge said about the connection, or like the proof of causation or connection when ruling on the MJOA on the permanent disfigurement or malicious disfigurement or the other count? Was the judge saying, government, you did not prove that whatever scar we see was even caused on this day?
Right, exactly. The court said the record does not establish that the complainant was permanently disfigured as a result of the assault. So the government.
Is that
right?
Yeah. Okay. Is that a finding that that we need to follow?
Well, to the extent that scarring or disfigurement might have been a factor in the jury's determination, our argument is that simply there was no testimony or evidence regarding that, and the trial court, in a position to be there and see that, also found that the government had not made a record of any kind of permanent disfigurement as a result of this attack.
It seems
But
like
if the jury saw scars in the same position as the photographs, as the scars were in the photographs, would it not have been a fair inference that they were caused by this attack?
Well, Your Honor, I think.
I mean, there's one scar that goes down the forehead. How many stitches? 14 stitches. If there was a scar in that position, I suppose someone might say coincidence, she did that a few weeks ago in some other incident, but I'm still inclined to think it's a fair inference that was from this attack. Do you disagree?
Well, we don't have any sort of idea of, there are a number of factors that play into the jury's ability to even see the complainant's face. Jurors' eyesight, the courtroom lighting, the angle of the complainant vis-a-vis the jury box, whether she was wearing makeup or not wearing makeup. We certainly know that the jury wasn't invited to look closely at the complainant, and we don't know how closely they did look at the complainant. the courtroom is a hectic place. It can be, there's shadows on the witness. The witness is not necessarily looking at the jury, looking at the prosecutor instead. So really, it would be conjecture to say that the jury logically took those scars into account, even if they were there. We have no record of.
I take it we don't have a jury note or anything of that sort that gives us a clue as to what the jury based its guilty verdict on.
No.
I think it's interesting, just thinking about the judge essentially, is this accurate, said in granting the MJOA, the government hasn't proved, I guess what would be an essential element of that crime, which would seem to be one that we also need here. And it's either we think, well, that's not true, we're going to go against what the judge said and say they actually did prove it, which would be kind of weird as to its effect on that acquittal, or we would say it doesn't matter, such as the government's arguing in its brief, we know the jury could have looked. And I guess, John, I'm just talking about the causation aspect of it. It's sort of weird. What do we do with that fact?
Well, the court has held that serious bodily injury is an injury that involves unconsciousness, which we do not have here, extreme physical pain, which we do not have here, protracted and obvious disfigurement, which we have no record of here.
Just pause on that, because in answer to Judge Beckwith's question, isn't part of the answer that malicious disfigurement requires permanent disfigurement and serious bodily injury does not?
Well, serious bodily injury requires protracted and obvious disfigurement. And the point is that there was simply no record made of the complainant's disfigurement. We don't know what the complainant looked like at trial. Or the jury, we don't know what the jury.
That's 3 years later. So sure, maybe if they don't tie those scars to the injury, they don't have permanent disfigurement the way they might if they tied scars 3 years later to it. But you might base protracted disfigurement, which can be for a shorter period of time than 3 years, based on the photos alone. Why can't you do that and have that be perfectly consistent with the trial court's ruling?
Your Honor, I think if anyone were to take photos of anyone directly after stitches, the photos look terrible. I think Ms. Appellant contends that asking the jury to look at photos is certainly going to be a disturbing, graphic thing for them. But the photos have to be accompanied by other information. Certainly the government, the photos played upon the jury's sort of, horror at this offense even happening at all. But there has to be more than the photos. The photos are part of it, but even the rest of what the government showed did not rise to the level of this exceptionally severe, if not unbearable, pain. And the court
Well, let's hear from Ms. Sprague, and we'll give you a couple of moments on rebuttal if you need them, Ms. Allen.
Thank you.
Thank you.
Thank you, Your Honor. May it please the court, Sharon Sprague on behalf of the United States. As a result of the conversation you've just been having with Appellant's counsel, I think there are a couple background issues that I wouldn't mind addressing right up front. One is the invited error concept that Judge Deal was talking about, and the other is the language barrier that Judge Thompson raised. There was a significant language barrier here, not just at trial, but during the incident itself. The victim was Spanish speaking. The two Good Samaritan witnesses who came to her aid and who followed the defendant were Spanish speaking. And there's a lot in the testimony about the difficulty they all had with communicating what was happening. In fact, one of the Good Samaritan witnesses, there's a lengthy explanation of his frustration that he couldn't get proper help on 911 because there wasn't a Spanish speaking.
But which way would the language problem cut? I mean, I agree it's a difficult problem, and I've seen it in many trials over the years, where you're just like, wow, this wasn't really a good trial, because you can't, it's hard to cross-examine. But how do you know, that she wasn't saying something like, oh, it wasn't too bad,
Right. And also, candidly, I mean, my first instinct was to kind of ignore it because we have what we have, and we have interpreters, and we should be able to, whether there's a Spanish speaking, assistant or not, we should be able to rely on the interpreters, and we should be able to ask follow-up questions if it wasn't clear or fulsome enough, and so on. So I understand that. However, in answer to Judge Thompson's question, which was, how does it really affect how we look at this case? And I think the way it affects how you should look at this case is to remember the standard of review here, that we are in, need to look at the evidence in the light most favorable to the government, and that I think only when the government has produced no evidence whatsoever is reversal appropriate. But I think it's even more appropriate here, where to rely on the jurors' evaluation of the witness's testimony. That's what I'm trying to get to. It's even more important that the jurors were there. The jurors saw Ms. Sanchez testify, saw the other witnesses testify, saw the language issues to the extent there were some. And I think the fact that there were language problems with the interpretation was highlighted by the prosecutor only suggests that there could have been translations that were not as detailed as they might have been. In fact, there was even a time when the prosecutor could tell that the answer was just too long for what was translated, and said, what else did she say? And the translator filled it in. It was not in front of the jury, if I remember.
But I think, Ms. Sprague, sorry to interrupt you, but something about sort of trusting the jurors, or they were able to see and experience this testimony seems sort of contrary to the whole idea of appellate courts judging the sufficiency of the evidence of a criminal offense. Like it's always a case where a conviction has happened, and as Ms. Allen was saying, you look at the photographs and you want to say this was serious in every way. And that's what we're here for, is to look at the evidence and make sure that, the elements were proven beyond reasonable doubt under our standards. So, is your point that what do we do with what you're saying?
My point is that we're talking about inferences. What inferences can fairly be drawn from the evidence that was elicited at trial? And we know from Gathy that a fair inference from just looking at those photos of how serious the injuries were, a fair inference is that there would be obvious and protracted disfigurement from them. And that would be true even if Ms. Sanchez didn't ever appear at trial. In addition, I think the other case that's instructive in this regard is Hollis, because there the jury saw photos that were 6 months after. Here we have the victim herself in court 3 whole years later, and both the prosecutor and the judge note that she has scarring on her face. There is just no reason to suggest, to believe that those scars on her face were not from this incident. And I think that's where we dovetail into the invited error problem.
But before you go there, can I just ask you about, was this Judge Beck? Is that who it was?
Yes.
Is it accurate that she said, government, you haven't put on evidence showing that the scar we see was caused during this offense? And if that went into her decision to grant an acquittal on that MJOA, what's the difference? Wouldn't that also mean the scar, even if we thought, oh, it's not permanent, but it is protracted, wouldn't that also mean that the government hadn't put on evidence that it had been caused by this offense?
Well, you would think that if the court wanted to go that far, the court might not have instructed the jury on the disfigurement way of
Yeah.
finding serious bodily injury, which wasn't the case. I mean, first of all, there can be inconsistent verdicts, as we know. Second, we think the court was wrong about that. And the trial prosecutor should have, I wish the trial prosecutor had said, but Your Honor, you can see, you can match them up and they match up. I mean, I understand that they did, that's not in the record, but I understand that they did match up. And I think it would have been good if the prosecutor had put that on the record. But that doesn't mean that I think the court was wrong to require that for the malicious disfigurement charge or for this one.
But did it nonetheless. So what is the effect of that?
Well, inconsistent verdicts are fine. This court reviews that the application of the law to the facts here in a de novo way. You just need to accept what fair inferences were there. And I think Gathy instructs that the photos themselves provided a sufficient basis.
So if the judge had said, I'm dismissing this malicious disfigurement count because I don't see a scar at all, then could
I
you
think
still come in here and tell us, well, the
wouldn't-
jury saw a scar or?
Well, I'm not sure, except that it wouldn't matter. I mean, the distinction is that permanent scarring was required for that count and is not required for this count.
Okay, sorry, fix my hypothetical so that to get rid of that problem. You know what I mean? I'm just like, to what extent are her findings?
Binding on
Yeah,
this.
are they? Yeah.
Yeah, well, they're not binding, number one. Number two, because as I said, there can be inconsistent verdicts. And second, she didn't say, I do, she mused, she was thinking out loud and she said, I'm not sure you made the connection. But when she made her ruling, she said, I find that you did not establish permanent disfigurement. That's all we have in terms of a ruling on that, granting the MJOA in that count. So
I'm just trying to think of another, sorry, I'm trying to think of another case where we are, looking at a sufficiency challenge on one count where we would say the judge had found some, lack of evidence on certain very similar elements on other counts. Sure, jury can do inconsistent verdicts, but when we're trying to assess the evidence, I'm trying to think of a case where we would ever say, well, the judge found that in this other case, but we're going to go the other way.
I think it's important to recognize that the court did not find that with respect to the ag assault charge. The court gave the full Nixon definition of serious bodily injury for aggravated assault. And there was never, and the defense did not object to the instruction. So it comes back to what this court has said in numerous cases, Hollis, Riddick, Gathy, that a properly instructed jury was capable of deciding whether the totality of the evidence satisfies the serious bodily injury standard. Here, there was no question that the jury was properly instructed. There was no objection. They had the written instructions back with them in the jury room. There was never any argument from start to finish that the evidence here did not meet the serious bodily injury standard. In fact, in opening, defense counsel said, we're
pause
not
for a
focusing
second?
on that. Mhm.
Because you're focused on sort of the MJOA back and forth. What's your response to after the judge grants? This kind of follows up on Judge Beckwith's question. After the judge grants the MJOA on malicious disfigurement, she asks, and is this disfigurement the basis of the aggravated charge assault also? And the government says, no, Your Honor. And then it goes on to detail things that are mostly, at least, not disfigurement related as far as its basis for malicious disfigurement. An argument from that the government just wasn't relying on protracted disfigurement as a basis for the serious bodily injury.
I interpret it, I wish there were more words there so we could get a little more information about what everybody was thinking. But from the words that are there, I interpret that differently because you have the judge just having ruled on the malicious disfigurement, saying that in her view, there wasn't the proper connection. Then you have And then she immediately turns to say, is that the basis of what you're relying on? And we say, no, it's not the basis. It's not the only basis. We say there is, quote, separate evidence. And we start relating the other evidence that we contend adds up to show extreme pain. So, the bleeding, the everything, the deepness of the cuts, all of that stuff. So I think we were not saying, and we never abandoned. We never, when it came time to talk about the offense in closing, for example, as the court noted, we led with the slashing of the face. When you read the whole closing, you can see that prosecutor had kind of run out of time, and the court said, you have like 2 minutes to sum up everything, and then started running through the elements. But why was there not more argument? And it just would be doubly unfair for the defense to rely on this at this stage in the game. But why was there not more argument about that? Because the defense said, even in the defense closing, defense counsel said, this has got to be the worst thing that has ever happened to this victim. There was never a
That's
challenge.
because it was a mis-ID defense. So in front of the jury, the
right, but the point is
defense
that
lawyer,
the point is that the defense counsel was never challenging the severity of the injuries, never, from start to MJOA to end. And admittedly, of course, the government has the burden and has to prove every element of the case. And that's why we collected in our brief and laid out for you all of the ways in which the inferences can be drawn to reach the conclusion that there was extreme pain and the protracted and obvious disfigurement. So, but I think the fact that there never was any argument on that did shortcut, to the extent anyone's wondering about why wasn't there more pushback on that, and then with respect to in the MJOA context, when the court says specifically to the defense counsel, do you agree that there was that the victim testified about extreme pain? Now, appellant just argued that it was a misstatement to say it was yes. I disagree. It was a appropriate concession. Why? Because, as this court has noted, extreme pain is a, quote, regrettably subjective feature of this. And you have to look at all of the totality of the evidence to assess whether there's extreme pain. Occasionally, someone will say, it was extremely painful, but most of the cases, those words are not used and they don't need to be used, as this court has made abundantly clear in a couple cases. So I think
in the prosecutor's closing argument, did the prosecutor try to match what was being described about the experience of the victim with the jury instruction, which told the jury about the bases on which it could find aggravated assault or could find serious bodily injury? I mean, I'm looking at the instruction. The court says it's an injury that involves unconsciousness, extreme physical pain, protracted and obvious disfigurement, protracted loss or impairment of the function of a bodily member, organ, or mental faculty, or a substantial risk of death. So there was mention of some of these other factors. I'm recalling the MJOA argument. There was the code yellow, and there was the loss of blood. In closing, was there an effort to sort of match what was being described to this definition of serious bodily injury? And if so, what was said?
Yes, there was. And the court can find it at page 225 of the transcript on the 10th, at the point at which they get to the aggravated assault charge. But I would also submit that everything that was said before is also relevant, because the prosecutor talked earlier about just describing the evidence. But anyway, with respect to the ag assault charge, the prosecutor said her face was sliced up. She lost a tremendous amount of blood just at the hospital, and that's separate from outside. And if I could just take an aside here, there was an immense amount of blood. The amount of blood that the doctor talked about at the hospital was only part of it. The blood was so bad at the scene that the fire department came to wash it away. But before the police even got there, and the police had to stop them because they were messing with a crime scene. There was a lot of blood, and there was never any question that there was a lot of blood.
What did that
There-
match up with? Was that substantial risk of death, or which one of
No,
these factors I read? Because
Well,
it doesn't say, obviously, it doesn't say a lot
it
of
doesn't
blood.
say, it doesn't
Right.
say, and it's true. And I did not read the closing argument or the government's presentation of the case as relying on a substantial risk of death. The three things that I think that it looks to me that we were relying on were extreme pain, unconsciousness, and I can talk about that in a minute, and the malicious and the obvious and protracted disfigurement.
If
The
you- Yeah, if you're jumping to unconsciousness, I think you're gonna have a hard time.
Well,
Because
it
you
was-
I'd like to
tried-
hear it, though. Tell us what you were going to say.
Well, it was,
Sure.
it's skimpy. Yeah, I mean, admittedly, skimpy, the evidence. That's why it shows up in a footnote in her brief. But she testified at the grand jury, the victim did, that she thought she lost consciousness. And that was used in her grand jury testimony, was used to cross-examine her at a time when the defense counsel was trying to show that she wasn't a reliable reporter about what happened on the scene because she really couldn't see and she lost consciousness and she wasn't paying attention. And she fought back, she responded on the stand. I now that I think about it, I don't really think I lost consciousness because I think I was aware of everything that was going on.
She was a little
So-
bit, she didn't equivocate that much. She didn't say, I don't think. They tried impeaching you with their grand
Yeah.
jury and said, well, didn't you say you lost consciousness? She's like, oh, that was wrong.
That's
I mean,
true,
I
but the
don't have
grand
it
jury-
pulled up, but
Well,
she
the
made
grand
quite
jury
clear
testimony-
that did not happen.
That's true, but the grand jury testimony did come in, the jurors that could have decided which they wanted to believe. Number two, there are cases from this court that talk not about full unconsciousness, but about semi-consciousness and about going in and out of consciousness. And that seems to be a more apt description of what happened here. And that may well be related to blood loss, and it may well be related to extreme pain, which is why I think we focused on extreme pain and on the disfigurement, that it's kind of more of a part of that. But to get back to the prosecutor's closing, prosecutor went on to say the victim felt weak. She felt like she was about to lose consciousness. And then I quoted this because I wanted to remember exactly what we said in closing. We heard her testimony about how much pain she was in after this incident happened. There was not a description of it. There was a reference back. And why perhaps would the prosecutor not go into a full description of whatever was said about pain? Because it wasn't being contested.
Right,
The victim's own
but
testimony was there. There
I'm
was,
sorry, Ms. Sprague, but as you said, the government's still going to have to prove the elements, and the jury doesn't know that, what's going on in the MJOA arguments. But the government didn't introduce any medical records or any evidence of I know in Medley, which is one of the cases you rely on, there's evidence of morphine maybe, or Percocet, some
Percocet,
pretty
yeah.
pretty
I mean,
hard
if the
drugs.
court would permit me a minute to just run through the evidence that I do think is there. I mean, we acknowledge from the beginning that the victim did not quantify the pain she experienced. The record does not disclose
But
how
I
she
guess the
rated
thing
her
is,
pain.
I'm sorry to interrupt, I'm being very rude, but
No.
it's like if she was in severe pain, it seems like the government would have easy access to evidence of the painkiller she was given. And, there's the absence of that evidence is, I don't know about telling, but,
Well,
interesting.
It's troubling. I would have liked to have seen the medical records myself in there. I know that the medical records were used. They were in front of the doctor as he testified, oddly, but not even admitted into evidence, because the trial judge kind of short-circuited that and said, does anyone mind if he just testifies from the records? So I wish that there was more of that in there, but let me just quickly run through for you how there was evidence of extreme pain. The victim's own testimony. She described her head as really hurting. She had trouble breathing, which is something we haven't talked about. She was punched in the stomach, lost all the air out of her. She said she was having trouble standing up, which is like Jenkins. The trouble breathing is very much like one of the the one victim in Bolanos where aggravated assault was upheld. At one point, she begged the assailant to stop because she, quote, couldn't stand the pain anymore. And that came in again through, it's another piece of the grand jury testimony that came in at trial. And finally, she thought she was going to die. She begged those bystanders not to let her die. Later on, she sought out one of the bystanders and thanked him for not letting her die. So all of those things are, and that's very similar to what happened in Bolanos as well. And all of those things warranted defense counsel's concession that there was testimony from the victim about the extreme pain that she suffered. And in addition to her own testimony, there was the testimony of Detective Hodge, who interviewed the victim at the hospital and said, quote, you could see she was in a lot of pain. And that's in the transcript of the 6th at 144. And then finally, I think there's just, as this court has said in other cases, there's the nature of the injuries. And obviously you've looked at the photos. The photos are very telling, but she was slashed across the face and forehead multiple times with a knife. She was bleeding profusely at the scene. I've already talked about the fire department having to come clean up. And at the hospital. The breath was punched out of her. She had trouble standing. So she was rushed to the hospital on yellow alert. All of those things are very unlike what happened in White and Jackson, for example. These were not, in short, these were not superficial cuts as in White or minor injuries as in Jackson or Swinton. She could not walk away as in White or Bolanos. Instead, the injuries here were deep cuts in very prominent places requiring immediate treatment and something we haven't talked about, layered surgical repair, which made them more akin to the injuries in Riddick, Hollis, Medley, Gathie, Jenkins, the other cases we've talked about in which serious bodily injury was found. So I think that given that this was a properly instructed jury and that all of that evidence was there, they were capable of deciding whether the totality of the evidence did amount to serious bodily injury.
Can I ask you a question about your invited error point, or your point about defense counsel agreeing there was evidence on the pain question? This kind of gets into I think you cite the Campbell case, or maybe Ms. Allen does, but this idea of if someone is going to trial on a mis-ID defense, and they're really not in front of the jury anyway, fighting the elements, they're still, we still want to have sufficiency claims, right? I mean, we ought to allow them to say, by the way, even though I lost this mis-ID, that was the way I wanted to go to trial and I thought was strategically best, but it turns out this also isn't, a crime, or it was, the elements weren't proven. Now, so are you saying this is waived or just forfeited?
We're not suggesting that there's not that we don't have an obligation to present sufficient evidence and that there's not a sufficiency claim that can be made. We raise that because in response to the defense suggesting that there should have been more, I submit to the court, and I think I just ran through it, there's plenty there. But why was there not more? Because that wasn't a contested feature of the trial. But there was enough there to make out the elements of the offense. And especially because there doesn't have to be direct testimony about pain. There doesn't have to be a matchup in court between the scars that were evident 3 years after the incident.
Well, I still have to believe, given the string of cases and the felony assault and ag assault cases where there have been reversals, I'm sure prosecutors know when they're going in, even when they're trying a murder case and they're not really that concerned about the separate ag assault, they still better put on the evidence, right? And so here, I think we've got this case law where it might, even if it's plain error, we've got a lot of decisions that say we don't want to affirm a conviction that's based on insufficient evidence. That itself would be some kind of plain error. Like if it's insufficient no matter what standard you're applying.
No, I understand. And I want to clarify one thing that I just said, and that is that, you know, when I use the concept of waiver, I think applies to the allegation now made on appeal that that the government put on that the victim never testified about extreme pain. That I think was invited error, because there very explicitly, that little point, very explicitly, defense counsel said, we agree. The answer was yes to the court's question, that there was, that the victim had testified about extreme pain. Now, as I suggested, it's not that the defense counsel was saying we heard the words extreme pain. It's that defense counsel heard the nature of the injuries, the testimony of Detective Hodge, the testimony of the victim, and concluded herself that that was enough.
So does that, in your view, mean we can't consider the extreme pain route to, you know, or we can't consider the insufficiency of extreme pain because of that?
No, I think it means that you can't, I think you can't consider that you have to accept that the victim testified about experiencing pain. I mean, you know, I think whether it's, you know, it doesn't put to bed entirely the proof. I understand that. But as I said, there's additional proof. We were talking narrowly about, did the victim say that? And remember that before that, even in the MJOA, the court chose to focus on that feature. But before that, the prosecutor's argument was, we meet serious bodily injury in any number of different ways. And we laid out a lot of different ways that went to a lot of different evidence. So I think, including talking about the unconsciousness. So I think that the court was concerned about that, and the court probably, I'm guessing, felt, well, if this is an easy one. If everyone agrees that the victim testified about extreme pain, then what's left? So I don't think it's waiver is meant for situations where I mean, you read the transcript and you see conversation was finished at that point. Okay, done. We're done with that. Now we're going to move on to other things. And there was no objection. If counsel thought that extreme pain was an inappropriate basis and unsupported by the evidence, you know, maybe they should have asked for that to not be in the jury, that in the instruction that went to the jury. There was
I've seen
This strikes me as analogous to one of those situations where we say, you know, the standard is objective. Was there a threat? It's not what the alleged victim perceived, but the fact that the victim perceived a threat is one piece of information that goes into a judgment about whether objectively there was a threat. And I take your point to be the fact that defense counsel, being there present and hearing all the evidence, thought that there was enough. And for all we know, maybe defense counsel spoke Spanish and understood exactly what the witness said.
and that's an excellent analogy.
Is a piece of information that we take into account.
Exactly. So I would urge this court, you know, especially being mindful, especially of the standard of review that we're under in the sufficiency case. I would urge this court to affirm the judgment of the Superior Court.
Thank you, Ms. Sprague.
Thank you.
And Ms. Allen, if you need a few moments on rebuttal, you may have it.
Thank you. The government talks now about factors that they relied upon to show the serious bodily injury count, pain, unconsciousness, and disfigurement, when in fact, from the trial transcript, June 10, on page 178, the court specifically says, which of those factors are you claiming was a serious bodily injury that you're relying on in this case? And the government says there was testimony that Ms. Sanchez gave about the extreme pain she was in. There was testimony regarding the immense loss of blood and that she was at yellow alert at the time she entered the hospital. There was testimony she had to be immediately taken into surgery because of the vein that was severed near her ear. That was not an injury. She could have gone home and treated on her own. And our contention is that the government failed to prove beyond a reasonable doubt, first of all, that vein was not severed. It was a blood vessel that was injured. that there was no testimony regarding unconsciousness, as the court has noted. There were 6 different opportunities when she was asked about unconsciousness, and the complainant said, no, she stayed standing the whole time. I was standing the whole time. I did not lose consciousness. I felt weak, but I didn't lose consciousness. I knew what was happening. I never went down to the ground. So there's just, our contention is the government did not prove beyond a reasonable doubt, especially the extreme pain component. Jackson held that in all such cases, they're talking about cases of aggravated assault while armed where the government's required to prove serious bodily injury. And all such cases have involved substantial and well-documented evidence of pain and related medical treatment, often including emergency surgery and lengthy hospital stays. That is simply not the case here. The government—
Ms. Allen, I'm sorry to interrupt. Do you concede that the complainant in this case suffered significant bodily injury under the felony assault statute?
Your Honor, we concede that the complainant needed medical attention in this case. She needed stitches. That's I don't think that's a question.
So, and you think that makes it significant bodily injury, that under the definition of those terms in that statute?
We think it's this, the facts of this case are comport more with significant bodily injury than aggravated assault while armed, and the requirements of exceptionally severe, if not unbearable, pain.
Thank you.
Is that it?
That's all I have.
Well, thank you. Thank you to both counsel for your arguments. Very helpful. And with that, we are adjourned.
Thank you.
This court is now adjourned.